Good morning. My name is Hae-sun Kim. Today, with the Gangnam Labor Law Firm Labor Attorney Jung Bong-soo, we will discuss about the difference between the freelancer and the official employee. Can we discuss about the first of the concept and difference of the two status?
Okay. Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. Like employer, they need to hire certain person so they can perform their the business or their duties to make money. So in this process, they want to hire a person with the most profitable way. So but if they hire a person as a freelancer, then freelancers, they are not loyal to them. They work for other people. Also, every time they employ user them, they have to have a separate contract. So it's very difficult to manage and control them. So employer try to hire them as employee, then employee must work exclusively for the that particular employer. Working hours, there are working hours or some particular workplace. So also they have to work certain period of time. So employee, they are controlled and they must work under the employee's supervision and control. So it is very different. The freelancer, they are free to work, so employee cannot control them easily. So employer should decide which type of person is good. Employer and freelancer is fully due to employee's discretion related to their work performance. Yeah.
I see. So in a number of occasions, we have covered some particular article on the Labor Daily, and in some cases, there were, because the employer did not differentiate clearly about the freelancer and employee, he has to pay a heavy compensation when it comes to the unfair dismissal. So can you remember some particular case where the employer did not compare clearly about the two status?
Yes, so there are a lot of confusion. Employer want to reduce or save cost, but also employee, they don't care. They only want to earn more money. So they, like employer and freelancer or employee, they make a contract. So in that case, for example, they make a freelance contract. So there is one case I want to explain. So that is a very famous Korean language institute, like CDI Institute. So there they have the service contract for teaching English. So in that case, they paid more, about almost twice than the other the English teachers working in other institutes. So in this contract, they stipulate that there will be no severance pay, no social insurance. So they look like they are hired as freelancers, but in this case, the English teachers at that CDI Institute provide the labor service from certain time, also designated area. Also they work the certain period of time, 1 year and 2 years. So employer didn't pay their like annual leave compensation or severance pay. So later, nobody complained because usually they earn more than other institute. So but one of some English teachers complained they are employees, so they could not receive severance pay. So I told them, you are employee, not freelance, so you are entitled to compensation for unused leave and also the severance pay. Also you receive the hourly wage based salary. That means weekly holiday allowance should be added. So I represented about in the beginning 12 foreign English teachers. Then later another 10 English teachers joined in this lawsuit because the company didn't pay severance pay and other legal allowances. So finally I won this case, so they finally received unpaid salaries for severance pay or other legal allowances. So this was a good example. Even though they make a freelance contract, but their actual working was like employee, then they are entitled to all legal allowances protected by Labor Standards Act.
I see. So do you want to recommend the employer to make it very clear when they enter a contract, like with the freelancer or employee, so the terms and conditions will be very different between the two?
Yeah, usually when employer deal with this contract, they must consider this is one time also professional service required to complete certain project or certain very short period of time. Then freelance is very recommended, but it's a long-term or regular service, or they need a very loyal employee who always work in fixed time, then they must hire them as an employee. Yeah.
I see. Thank you very much. Do you want to make any more comment about this?
I think this is a very common issue, so it is decided by actual practice, even though the title of the contract is not important. Only in the translation of the certain cases, we judge the case based on actual practice. So name of the contract, like freelance contract, employment contract, is a secondary translation, but first translation is decided by actual practice, how employee or person worked there. So that's important.
I see. Thank you very much. It's very helpful.
Okay, thank you for watching. Bye bye.